Good evening, everybody, and welcome to this evening's webinar with the Tenant Farmers Association. My name is Robert Martin, and I'm the National Chair who recently took over from Mark Coleman. So tonight's webinar, which I've really been looking forward to, is what difference will the new Code of Practice make to landlord-tenant relationships in agriculture? And I was very fortunate to go down to the Farm to Fork Summit on the 14th of May in Downing Street when the Tenant Farm Commissioner was announced. And I was overjoyed with that because that's been one of the main things of the ROC review that I wanted to see put in place. This evening, we're delighted to welcome Matthew Morris, the Duchy of Cornwall and Chair of the Code of Practice Expert Working Group, and Charles Cowop, who is the Code of Practice lead author, and they are our guest speakers this evening. I would like to pay tribute and kindly thank our sponsors for this evening, who are Roythorne Solicitors. Roythorns have kindly agreed to support the 12-month period of the TFA virtual events, as well as other TFA digital knowledge share content. Roythorns is a national law firm steeped in agriculture. They have 90 years of expertise advising landowners and tenants alike. Their lawyers are active in the farm tenancy policy groups. They get the bigger picture. So whether it's a succession application, a new farm business tenancy, they are the people to go to if you're looking for advice and assistance. Tonight's webinar will be recorded and once edited will be available on the TFA YouTube channel. To find that channel, just go to YouTube and search at Tenant Farmers. Our video library features all our past virtual events, knowledge share teachings. We encourage you to visit and subscribe to the channel so that you can be notified when we upload new content. Our content in the past has described and looked at DEFRA Elms SFI, reimagining the landlord-tenant relationship in agriculture, and the Dartmoor Review, conclusions and impact on other protected sites. So moving on to this evening's webinar, I'd like to talk about our two speakers and introduce them. Matthew Morris. Matthew is a rural director the Duchy of Cornwall, the private estate of His Royal Highness Prince William, Duke of Cornwall. With a specialist team of land agents, building surveyors and future farming advisors across 5 regional offices, Matthew has strategic responsibilities for the Duchy of Cornwall's rural portfolio, which extends to 130,000 acres, woodland across 20 counties and 270 equipped holdings. Previously, he had been estate manager for the Bosworth Estate in Cheshire, managing a portfolio of dairy farms and cottages. A firm advocate of the importance of the tenant sector, Matthew was on the tenancy working group, which helped produce the ROC review. Matthew also chaired the expert working group, which on behalf of the Tenant Farmer Forum produced the agricultural landlord and tenant code of practice, which I mentioned earlier, which was published in April of this year. Our second speaker this evening is Charles Cowop. Charles is the author of the Agricultural Land Tenancy Code of Practice for England. He worked through several versions of the document with members of the Tenant Farming Forum expert working group to arrive at the final publication version of the code, based on early agreements of the 3 principles of clarity, communication and collaboration. Charles is a visiting professor at Harper Adams University. In 2022, he sat on the tenancy working group alongside our chief executive, George Dunn, supporting Badness Rock in the production of a report. Charles is a chartered surveyor who specialises in rural estate economies and strategy. He is the chair of the Organic Farmers and Growers Certification Committee, and Charles also is no stranger to the TFA, having been guest speaker on 2 of our previous seminars, which focused on natural capital opportunities. So I think that's been quite a good overview of our speakers this evening. We also have on this evening George Dunn. He's our chief executive for the last 27 years. So he seems to have forgotten more than what most people know. So we're very pleased to have George on tonight when we come to our question and answers. So I think after that introduction, I think if I can just ask Matthew to give an overview of what his thoughts are, and then we'll move on again. Thank you, Matthew.
Thanks, Robert. Good evening, everybody. So yeah, delighted to chat to you this evening about the code of practice. Let me tell you a little bit about how it came about. George and I were involved in the ROC review, along with Charles. We were involved in the sort of the process of evidence gathering that Baroness ROC went through to really understand what was happening in the tenanted sector. And as part of that, there was I think Baroness ROC called it the ROC Roadshow. She went on the road around the country, gathering evidence, talking to farmers, and really understanding and getting under the bonnet of what the issues were in the tenanted sector. And I attended a few of those sessions. I remember I attended a session up in Cheshire, surrounded by some familiar friends from my days up there, but really listening to kind of what's going wrong in terms of communication, particularly between landlords and tenants, but also recognising that communication, the problem can often sit with the agents rather than with the individuals at either end of that agreement. And I've been a chartered surveyor now for quite a few years. I've slightly lost track how many years now, but a long time. And I've predominantly worked, I've only worked on the landlord side of the fence, so I'm going to hold my hands up. However, I recognise that there's good and bad practice in the sector. I think we've all seen it. And I think we've all seen it on both sides of the fence. We see agents taking negotiations to the wire. We've seen agents sort of, not supplying information in a timely manner. And we've seen agents just not communicating with each other. And from a farmer's perspective, all that leads to is delay, and in many cases, further costs as fees just rack up. And this isn't all about delay. This is just about making sure that the sector is working better together for the benefit of you all as farmers. And I think that was kind of our starting point. The ROC review said, we've got a problem. The tenancy working group have said that we need to look at this code of practice. And I was asked by the then Secretary of State to chair a working group to try and come up with a way forwards that the industry could get behind. And I think the important thing is that this was a pan-industry approach. So as well as George and myself and Charles, we were joined by representatives from RICS, from CLA, from NFU, from the Agricultural Law Association. We had institutional landowners represented. We had young farmers represented. It was a pan-industry approach, which was great. It was no small challenge to try and get all of those different organisations to agree, but between Charles and I and the panel, we got to a document that all of those organisations could stand behind, and that is the code that has been published. And crucially, it's an industry code. We wanted it to have a life beyond the current Parliament. Who knew it was going to be such a short life? But we wanted to make sure that this wasn't just another DEFRA initiative that just had a short shelf life. This has been signed up to now by all of those organisations, which for me is brilliant because it's going to give it teeth, both in terms of longevity, but also from a regulation point of view. You've got the likes of RICS who are going to sweep it into their suite of regulation for firms that carry the firms and practitioners that carry the RICS logo. That's fantastic. We've got the CAV as the other main sort of professional land agent body. Again, the CAV have said, yeah, we're happy and comfortable and endorse the code. So from my perspective, that's a huge win that we've got a code that all of those organisations are getting behind. But I think before I hand over to Charles, the one thing I want to say is Charles has delivered a code, and I always said that I wanted it to be something that could sit on the kitchen table in the farmhouse, and you don't need a solicitor to interpret this code. It is written in plain English. it enables you as farmers to actually call your agents, whether they're acting for you or for your landlord. You can wave it at them and say, guys, you need to, or girls, you need to come back to this code. You're not behaving in accordance with the code. So really, I see it as something that can empower you all as farmers. It can sit there, you can refer to it, and it covers a whole range of different scenarios, which I think we're going to touch on this evening. And we've had some really good questions that have flowed through as well. I think it's going to hopefully provide some clarity for the sector as to how people should behave, and ultimately, if people don't behave, then there will be ultimately sanctions through their own respective professional bodies. So it's been a really positive experience. I will say that working alongside the TFA to help not just deliver this document, but also the ROC review. I will just say that George has been a huge advocate for the tenanted sector throughout. The panels, the people involved have not always seen eye to eye, but I think we've all come out of the process feeling that actually we've reached something that as an industry we can all get behind, and we've all remained great friends at the end of it, which I think is also testament to the professionalism with which everybody's approached this. So I just wanted to say thank you to George, and also thank you to Charles as my as the author who's helped us pull all of these strands together. And it was a bit like herding cats occasionally, but we've got to a code which we can all stand behind. So I'm going to hand over to Charles now, and then we're going to come back to a Q&A a bit later.
No, well, that's fantastic. Thanks for that, Matthew. It kind of lays the path out of what we're looking at this evening. You mentioned in your piece there about questions and answers for tonight, and I just want to remind everybody who's listening tonight that if you have any questions as we go along, put them into the Q&A session at the bottom of your screen, or it may even be the top of them on what your computer is, and then we'll pick up what those at the end of our presentation. We've already had a look at questions in already, and I think we'll just hand over to Charles, please. Thank you.
Thank you very much, Robert, and thank you very much, Matthew, for your kind comments about my contribution to all this as well. George has been very disciplined about our efforts this evening and sent me a list of 5 questions which I have to answer. So in the next few minutes, I hope to set a fine example to any of you who might be standing for office in the next few weeks. Or so. But before we get to my 5 questions, we do have a number of polls that we want to use to gauge your opinion this evening. And Julia is going to be the maestro of the polls. So Julia, could we have the first one, please? And I think it should have appeared on your screens. And if you could just click on your choice, I will try to temper my comments to the profile of the responses that we see. In other words, if you all click excellent, we can all pack up and go home early. And Julia will tell us when we've got some responses to be able to consider. This is completely anonymous.
Absolutely.
As it happens. So if any of the duchies are your landlord, Matthew won't know.
Yeah, well, Matthew's wearing a very hard hat tonight and a flak jacket. So
and a flak jacket, and I'm not allowed to vote either. So there we go.
No, you're not. I saw that.
Fixed.
Yes, we're not allowed to vote.
No, goodness me.
Yeah, Julia, do we have enough? Do we have enough in the way of responses now to take the temperature?
Oh, there we go. Our screen's gone.
There we are.
Bit like
some results.
There we go.
We are. Well, it's very sorry to see that there are a few appallings in the room tonight, and the pause for that matter. Yeah, we have a smattering of excellent goods and fares, and those of you who are familiar with the idea of a bell curve would expect that it would kind of follow that shape, wouldn't you, really? Very few at the top and bottom, and most grouped round the middle. But small numbers, I know, must be careful what to make of them. But it's a shame to see that number at the bottom. there. But perhaps that's why you're here tonight. So you may be a self-selected audience as well. Thank you, Julia. We can dispose of that now. And I shall come to the first of questions which George has posed to me. So this is the first question of 5. And George's first question to me was how the code will be embedded into everyday practice. Now, we know that the government announced the appointment of a tenant farming commissioner, but that lies ahead. So let's just set that to one side at the moment and think how it will be embedded. I think working practices, if they really do adopt the code, will start before a tenancy is even set up. They will start with the tendering process, because that is the first section that we cover in the code. What should be good practice during tendering for a tenancy? I think also, reflecting the code in tenders, it will be great to see if firms, in particular firms of land agents and other advisors, actually sign up to the code. And some have said that they will do so. And I don't think we can expect all landlords to make an awful lot of fuss about signing up to the code, but certainly if the larger ones who have significant land holdings are able to publicly say, we think this code is a very sensible thing and we will be adopting it in our work, as some have done, that will be excellent as well. Moving on from that, tenancy agreements. I'll say a little bit more about tenancy agreements in answer to George's second question. But we also have the role of the institutions like the RICS, the Royal Institution of Chartered Surveyors, and the CAV. More to come in answer to the second question about that as well. And the last group that I would like to emphasize in answer to this question is the role of the arbitrators and the first-tier tribunal. The tribunal that deals largely with tenancy succession applications, but also one or two other matters that come up on farms as well. And if we could see the message coming back from those, particularly the first tier tribunal, because they work more in the public in the public domain, where we can see their decisions. Arbitration awards are of necessity confidential between the parties, but nevertheless, word spreads that the arbitrator took a severe view of non-compliance with the code, and that has cost somebody some serious money. I think there are several ways in which it would be quite feasible, quite realistic to see the code embedded into everyday practice. So tender documentation, tendering procedures, tenancy agreements themselves, big firms, big landowners endorsing the code, and arbitrators in the first tier tribunal on the disputes that get there, also being seen to be guided by the code. That's my first question. George's second question to me was, how will organisations like the RICS, the Central Association of Agricultural Valuers, and the Solicitors Regulation Authority integrate this work into their regulatory functions? Well, we already know that when the code was published, the RICS announced that it would take the code into account in judging what amounts to good practice amongst its membership. What that means that if Matthew or I find ourselves reported to the RICS for some misdemeanor or other, and if part of the evidence against us is that we have departed from the requirements of the code, things may not go at all well for us. I think we had hoped that the RICS would fully accept the code as what they call a professional statement, which for people like Matthew and me is the ultimate professional guidance, really. But the RICS hasn't gone that far, but nevertheless, they have gone a long way. And this is an announcement they've made publicly. It's not just something they've said to chartered surveyors. It is there in the public domain for anybody to see. The CAV has also incorporated the code into its model farm business tenancy agreements. These are agreements which are often used by agricultural valuers as the start point for a tenancy agreement between landlord and tenant. It's clearly up to the individual valuers concerned and landlords and tenants how they adapt that code, but it's great that it's in there as a prompt to the parties to reflect the code. The Solicitors Regulation Authority, frankly, I think I have to say, I suspect that we're below their radar. Their breadth of interest is so great, and agricultural law such a specialised area within the purview of the Solicitors Regulation Authority, that I don't think we shall be there. Some other thoughts on this question of how will organisations integrate it into their regulatory functions? And I'm moving on from regulatory functions in answering the question, but I think it would be very encouraging to see DEFRA continuing to lay an emphasis on the code, perhaps incorporating the code into some of its requirements and guidance around its support schemes of one sort or another. And I think it would also be good to see it coming through from some of the supply chain organisations as well. So to take one, I mean, I know, it comes in for some bashing, but the Red Tractor scheme, for example. What about if schemes like the Red Tractor scheme were to say, well, if you want to get our certification, you need to be signed up to the code of practice for landlords and tenants, or be seen to be working towards it. So that's my answer to the second question from George. How will organisations integrate this into their regulatory functions? Question number 3 from George was, should the code be part and parcel of new tenancy agreements? And the answer to that must be an unequivocal yes from my point of view. So I can probably move on to question 4 at that point, but that would be to sell you a little bit short, I think. One point about the code is that it's deliberately not written in the language of legal agreements. We avoided legalese. It has a lot of shoulds, but that begs a question of, well, what if you don't? Really, it is a voluntary code. And I think that the extent to which it is fully written or referred to into tenants agreements really needs to be judged in the light of the tenancy agreement. And I draw a distinction here between a new letting on a 20-year farm business tenancy of a 700-acre farm. Definitely yes to that. A farm business tenancy, which is little more than a short-term grazing license, very good if it's there as well, but I think that's probably less important than the big, full, commercially equipped farm. I think also that question narrows the focus too much, because it kind of leads you to the view that the code is about tenancy agreements. And it's not. It's about much more than that. It's about how the tenancy is granted in the first place, the tendering or whatever other arrangements are referred to, and how we all behave once we have a tenancy agreement. We don't have a poll on this, but I suspect if we asked you when you last read your tenancy agreement, not many of you would say in the last year or two. And it's much more important that your day-to-day working is in line with the code. So yes, but it's not just about tenancy agreements. That's the answer to question 3, should the code be incorporated? The 4th question that George put to me was this: give a practical example of a landlord and tenant dispute and how the code could be used to the advantage of both parties. And first of all, I'm going to be picky with George about that because he asked me to give you an example of a dispute. And the code isn't just about disputes, no more than it's just about tenancy agreements. So I'm going to take an example which is probably the most common experience that you all have as tenants, and that's the rent review. Let me describe how a rent review happens now, and you're welcome to put in the chat box or the Q&As that I've got this completely wrong. Here's my characterization of a rent review now. Let's say you're on a Michaelmas tenancy. Sometime in September, a notice without much explanation arrives from the landlord challenging you to arbitration in a year's time. It's a really good opener to negotiations, isn't it? We're going to bang you into arbitration. Then nothing happens for about 11 months or even more, and then there is a mad scramble while we shout at each other about what the rent or rent shouldn't be. Such is the madness of the scramble that we are even banging in requests to the RICS or the CAV or the Agricultural Law Association to appoint an arbitrator just so we can keep the discussions rumbling along. At the 11th hour, probably the 11th hour and the 59th minute, we settle what the outcome of the rent review will going to be. That's a really good way to go about business, isn't it? I think that if you follow the tenets of the new code, it will work like this. Before the notice is even served, you will be having pretty regular discussions with your landlord. So it will be no surprise that a rent review is coming up. The code refers to that as routine engagement and encourages it as being a jolly good thing. Speak to each other regularly. Sure enough, that notice has to be served. It's the law, it has to be done. So with just over a year to go, the rent review notice is served. But it doesn't come out of the blue because of the routine engagement. And with the rent review notice, whether you serve it on the landlord or the landlord serves it on you, comes a note saying, here's your rent review notice. I suggest that we get together in about 6 months' time. Here's a few dates that would be useful from our point of view, just to talk through some of the issues. That if it's a big, complex farm, it might even be that that's in 3 months' time. So that's this big, complex farm, lots of buildings, lots of land, lots of different enterprises. So the suggested timetable that's sent with the notice says, let's have a discussion about this in 3 months' time. That discussion is wrapped into the routine engagement meetings about all the issues affecting the industry, affecting the farm, about where you're going with your farming and personal plans and all the rest of it. Next, we have a discussion at about 6 months to go, where we start to put figures on the table. The landlord is saying, look, this looks like the pattern of rent reviews. This is looking like what it should be. This is the evidence we've got. You're saying, well, okay, but I've heard of these rents and actually looking at my budgets, this is what they're looking like and what is affordable to me. Other issues are on the table now. Look, you haven't done any repairs for the last 6 years. Can we just incorporate that into it? The slurry store's falling apart. We really need to address that. Can you put anything into it? Those discussions then continue in an orderly sort of way, so that at least with 2 months to go, there is a definite proposal from whoever initiated this rent review on the table. Then you've got the final haggling for about a month or so, and with a bit of luck, with 3 or 4 weeks to spare, you have settled a rent. You do the documentation, you sign up, you get on with your life. You've had no need to worry about instructing arbitrators. You've had some useful and constructive discussions along the way. That picks up 2 parts of the tenancy code. One is how to deal with rent reviews, most obviously, but something that comes before it in the code is the emphasis on routine engagement. Now, this is not a hands-off relationship. You don't have a discussion with the guys who buy your milk every 3 years. You're in touch with them constantly. You don't have a discussion with the guys you sell your corn to every 3 years, or the guys you buy your fertilizers from. Why should it be any different with your landlord, who is one of your biggest regular outgoings, and on which relationship everything else depends? So, Julia, we have polls 2 and 3. Could we have a look at those now, please? And this one, I hope it's self-explanatory, but how often do you hear from your landlord or his agent or her agent about the farm? And I emphasize this is how often does your landlord or the agent contact you? And once we've got a halfway decent number of responses, Julia, we certainly don't need to have a complete census. The sample is fine. Just share the results with us if you would. And there we have it. Very good. Look at that. More than twice a year. That's good at the top, isn't it? About once a year. That's not bad at all. But we do have quite a number at the bottom there. Only when issues arise. Hardly at all. Right, Julia, can we now close that one and move on to the next one, please? Now, this poll is the opposite side of the particular coin. How often do you contact your landlord or the landlord's agent? And again, Julia, we just need a quick snapshot. We don't need to dwell too long on it at the expense of our questions later on. There we are. It's not that dissimilar a pattern, actually, looking at it, is it? We've still got quite only when issues, hardly at all, unless I really have to, at the bottom there. And a dip in the middle, but more than twice a year at the top. Thank you, Julia. That's very helpful. We can push that away now, because I still have 2 questions to go. No, I have 1 question to go. The last question that George put to me: what should be the sanctions for people who do not follow the code? And having sweated blood writing it several times, I think the obvious sanction for anybody who breaches the code is that they should be taken from this place and hanged by their neck until they are dead. But that probably does seem a bit extreme in 2024. I do want to emphasize, though, that people includes landlords and tenants as well as agents. So we look at those 3 broad groups. Landlords, what sanctions could there be for landlords? Reputational damage, name and shame. Certainly that would run big, I think, with the big institutional landlords and some of the larger estates. For tenants, what should be the sanction for tenants who don't use the code to advantage? I imagine that a tenant who hasn't done, who is applying for future tenancy, could find it difficult to get decent references for that future tenancy. And again, reputational impacts might be considerable. That doesn't really amount to much for landlords and tenants, does it? For the agents and advisors, actually the same factors hold good as well, but actually they are also part of professional disciplinary networks, particularly the chartered surveyors. The RICS does have a large disciplinary department which is well geared up for putting Matthew and me through the mill when the need arises, and that does lead to publication of disciplinary outcomes as well, which isn't a nice thing to see your name in, really, and is an awful lot of trouble to deal with it as well. So That's the sanctions. But actually, let's turn that around. What are the rewards for people who follow the code? I'd like to think that one of the rewards for landlords and tenants who follow the code is that they get a better working relationship and they both share in greater prosperity. What could be a better reward than that? I think for agents who follow the code, I'd like to think too that they get a good reputation for fair dealing as agents who get the job done, who are helping the industry, who are helping the landowners, and that generates good business for them as well. Throwing that a bit further, what about some recognition schemes? What about the Tenant Farmers Association Landlord of the Year Award, the CLA Tenant of the Year Award? And of course, I make all these comments before we have in place the new Tenant Farming Commissioner, because we are promised that later in the year. Who knows what the political outcomes will be. So to some closing thoughts then, everybody. The code. It's not a stick. It is meant to be a helping hand. Please view it in that way. Secondly, I think the code is an opportunity to build on what is there, if it's sound, or to lay new foundations if there is nothing there, or indeed to repair damage where that might need to be repaired. Thirdly, I'd really like you to give George and his colleagues feedback on how you find it working and how it's helping. Fourthly, the code is not just to tell landlords what to do, it is for everybody. So please seize the initiative. Hang on to this point about routine engagement. Get in touch with your landlords and say, hey, we've got this new code. We should be talking to each other from time to time. When can we meet? Let's get a date in the diary. IRE, initiate routine engagement. And fifthly, picking up the three broad principles of the code: clarity, communication, and collaboration. In preparing for that, make sure you are clear as to your needs and your expectations and your plans. Make sure that you can communicate those things as clearly as possible. Not all landlords understand farming very well, so they may need some help. And thirdly, look at how you can collaborate to mutual benefit. That's the point I want to finish on. Let's have some questions and answers. Thank you for your attention.
Well, thank you for that, Charles. It's been a tremendous, concise review of the code. And it's interesting that when you think about how it's happened, you shouldn't really need to tell people how to behave, I don't think. All the people, you should know that. But I think this is a tremendous outcome from the ROC review, along with the Tenant Farmer Forum, and also the Farmer Commissioner to be announced this autumn. So we've talked a lot about questions and answers here, and it's now time for everybody to ask their questions. You've got the live chat there for question and answers on the screen, and so I'd like to bring Matthew into this, and also George, and we have quite a number of questions that have been submitted prior to tonight, and then we've got one or two more that's coming after, and whatever comes on the screen. So we're doing really well, actually. I think our first question's already been answered, really, because they talk about if individuals don't do what the code says, should they be named and shamed? So I think you've talked about the sanctions and issues that they may find about either the tenant not getting more land in the future or the landlord finding it very difficult to get tenants. So I think we'll pick that one up. Our second question here, and this is for all you if you want to comment, without wanting to be negative, if in the end there is no movement forward, better relationships, should the code be transferred to a statutory or regulatory basis? I don't know whether you want to pick up on that, Charles, first.
Yes, very happy to do so.
Thank you.
I think step by step. Let's see how it works a bit before going too mad. We are promised the Tenant Farming Commissioner. What happens to that in the light of the general election? I don't know. Others here may have a better idea. Once we get this Tenant Farming Commissioner, the Tenant Farming Commissioner won't have the same powers that the Scottish Tenant Farming Commissioner has. I think we tread carefully. Let's give the voluntary code all the chance it can. Let's give it a big push, because there are always unforeseen consequences, unintended consequences of pushing too far with regulation. But on the other hand, you know, if problems don't go away, let's not sit on our hands either. You know, maybe as an industry we should think about, let's give it a year and see how it's doing. So that would be my thought, I think.
I think, Charles, I agree with you. I think it needs time to bed in and people to, to become more aware of it and try it out. On the poll we saw, there are some communications aren't happening regularly yet, so let's allow it a bit of time to bed in. But I think, Charles, you probably agree. We went to great lengths to make sure that the two main regulated organisations within our world, both the Agricultural Law Association and CAV and RICS, all three of those organisations were part of and signed up to this code. So I think if it's not working, then the first port of call is going to be those three organisations to make sure their membership is abiding by the code. But of course, the membership is only representing the agents on both sides of the fence here. So there's that added teeth that may be needed if landlords and tenants themselves are not, if they're choosing to represent themselves, what do we do in that situation? Because they might not be members of ALA or RICS or CAV. But I think it's as you say, Charles, I think it's baby steps. Let's see how it evolves. Let's see how it works in practice. The more we can get it out there, the better. I don't think DEFRA had the budget for printing, and we're trying to live in a paperless world. But there's nothing quite like having that bit of paper, that little booklet sat on your kitchen table. There we go. Charles has printed his out, but I'm thinking we might print it for all of our tenants in the Duchy, because actually it's a really good thing, and also. Choosing our moment to introduce this into conversation, I think, is really good. And there are always trigger points in the life of a tenancy. And I've recently had a couple of succession conversations over on the Isles of Scilly, and I've said to both of those farmers who are hoping to succeed, I said, look, we're going to go through this process, but we're going to go through this process with the code in front of us, and that's how we're going to go about our dealings in this process. So it's just choosing your moment, whether it's a rent review. Whatever the trigger is for that next conversation with your landlord, bring the code into the conversation and make it part of the normal conversation.
Well, can I chip in on that one? And I absolutely agree with both Charles and Matthew that we should be giving this code every opportunity to have the influence that we all hope that it will have right across the piece. But I think it just bears remembering that we are operating within a system where landlords and landlords agents have traditionally not had to try too hard, because there are many more individuals out there looking to take advantage of a tenancy of land than there are individuals offering land. And therefore, landlords and landlords agents haven't had to be investing in relationships to the same extent as they might have done if it was in a commercial setup where you were looking for tenants and you had significant void periods. So I think that just bears thinking about. But also, in terms of this bit by bit and step by step approach, let's not forget that prior to the ROC review, the system was saying, we don't need a ROC review. Everything's working fine, don't worry. We've got the Tenancy Reform Industry Group, it's fine. Then we had the ROC review, and then we were told, oh, we don't need a code of practice. The ROC review's wrong, we don't need a code of practice, everything's fine. But actually the evidence was quite clear we did need a code of practice, and now we've got an agreement across the industry that a code of practice should be introduced, and a good code of practice has been put forward, which has, as Charles said, messages as much for landlords as it does for tenants in this. Then we were told we don't need a commissioner, ROC review's wrong on the commissioner, and now all of the political parties I hope all the political parties agree that a commission is needed. At some stage, the system has got to wake up to the fact that things have got to change. And I really do hope and pray that this is the moment that the system wakes up to that, because I don't want to see this becoming a piece of statute or a piece of regulation. It's got to change hearts and minds. And this code is a good code, and we need to make sure that it does change hearts and minds.
No, absolutely, George. And it's nice where Matthew was saying there that we'll get it printed and put it on the desk or the farmhouse table of everybody, so that we all know where we're going to be. And we've talked tonight a lot about communication, and we have a question here from a practical perspective. Is there an online resource to support or promote the code at this moment? I don't know whether, Charles, you can pick up on that.
The code itself, I would say, is the online resource. It's available from all the endorsing organisations' websites. Quite often things are so complicated that you need the kind of simple guide to them. But the code is only 11 pages long, including the introduction, and the pages themselves aren't very full, in all honesty. So rather than rely on anybody else's commentary on the code, I would just say get a hold of the code from the TFA website or any other websites. Read it for yourself. If you've got any questions on it, bang them into George. I'm sure he'll be a very good conduit to anybody else on the working group who he might need to refer to. But I'm sure you'll get a pretty comprehensive answer from George, because he was there every step of the way when we did it. So,
and Robert, yeah. I've already been really impressed and pleased with the extent to which the sector has picked up the code. And, as Charles has said, it's already included within the CAAV standard tenancy agreement. I was listening to a podcast from a well-known firm of solicitors this week where the code was talked about extensively in terms of the impact it was going to have. And I've seen it reported in other professional magazines and online forums, etc. So I think, as Charles said, there is a significant amount of effort from the system to say, look, this is an important document and everybody should be looking at it and taking notice of it. So I think my view is Charles's view, that this will have a life of its own online, and it doesn't need a sort of all singing, all dancing piece of machinery behind it. And organizations like ours will absolutely be willing to take the views of its members about how it's operating in practice.
No, well, that's fantastic, George. It really is. And we're all down to communication here. We have a question here. Use an example of rent reviews, in particular HA reviews. Do you see hope the code of practice will prompt land agents who initiated a rent review to calculate their proposal in line with the Act and willing to share their evidence to justify the rent proposals? In essence, will the code promote land agents to do things correctly and encourage more roundtable discussion and to come up with sensible discussions? I don't know whether you're going to pick up with that, George, first, maybe.
Well, maybe we should ask a landlord that question, shall we?
Well, I think that's good.
Mr. Morris.
Oh,
Thank you.
We have
Thank
one
you.
in the room.
Well, I would always advocate for a spirit of openness when you're trying to agree a rent. I mean, at the end of the day, I think what the code does is it introduces that degree of communication, the regular engagement. I think the landlord and the tenant need to be able to share their aspirations, what their challenges are. Let's be honest with each other, and let's just say, look, this is our vision for our organisation. Where do you want to take your business? And I think the deeper understanding that you gain of where each other wants to be, the better you can have those conversations come the hard numbers conversation of a rent review. And I think we've all been a bit like this, haven't we, with our numbers? And it's both sides. We'll never quite, from a landlord's perspective, we'll never quite know how profitable or otherwise the farming business is. But the more we can share that information, the better. And thinking laterally, and even within an AHA envelope, thinking laterally about how we agree a rent figure. There is nothing to say that you can't think outside the box in terms of that. When I was at Bolesworth, I was there for 16 years. I never fell out with a tenant over rent, and the reason for that is that the we had a rent formula that took care of it. We were in complete transparency of numbers. I saw all of their milk statements. We absolutely understood each other's business, and that was really empowering. So I'd always be an advocate for just being honest and open, because if we can't share that, and it's got to work both ways, though, I would say, George, it's got to, because you will have good years and bad years. We all have good years and bad years. We need to be able to share that, and we need to see the direction of travel of the business. We need to know what your investment requirements are. It's that bigger picture thinking, and I think the code, I hope, provides that framework for that regular engagement, which has slipped away in some cases. And I've been in organisations where you only go to your farm every 3 years to do a rent review. That's no way. We should be on farm much more regularly. We should have our finger on the pulse, not just on that farm, but where farming is at any given moment. So I think, communication it comes through loud and clear, and making sure that we're not hiding behind our pieces of paper. I think that's really, really important.
Well, that's absolutely fantastic. That it really is, and it's nice to hear it from someone who's working with your tenants day in, day out as well. I don't know whether you want to comment on that, Charles.
I don't know when Adriana posted the question, but I'd go back to my answer to the question about how does it work. Serve the rent review notice, set out a timetable, have some discussions. Whoever initiates the rent review, get some proposals and thoughts on the table. And I think this question asks about agents setting out their thoughts on how it lines up with the Act. I think that fits exactly in with what I just outlined.
Yeah, no, that's good. And another question in here. I have a good working relationship with my landlord, but the agent is a nightmare. However, the landlord seems unable to make his agent behave in a better way. How will the code help me in this situation? Charles?
I'm happy to have a go at that if you'd like me
to,
Robert.
Yeah.
First of all, I think you can wave the code in front of both the agent and the landlord. I think it's great that the questioner has a good relationship with the landlord, because sometimes the tenant hardly knows who the landlord is, and it's all done through the agent. So this is a better start point than that. I think if you can get that routine engagement going, perhaps part of the routine engagement to start with was, let's talk through this code and how we're going to apply it in this tenancy. If at least some of those meetings can be with the landlord present, preferably with the agent as well, I think you might be helping to set some expectations up on the right lines. A self-serving agent might see merits in divide and conquer. There's very little merit in that. There is every merit in everybody talking to each other, in the landlord being very clear to his agent what his expectations are, and those being very clearly on the table to the tenant as well. The converse of that is that sometimes affable landlords wonder what the point of keeping a dog and barking is, so they expect their agents to do their dirty work. So do beware of that as well. But again, getting them both in the room at the same time has to be a good way forward. Ultimately, if the agent is really an obstacle to progress, then I'd suggest the landlord should get another agent, but it is open to either party to take up the question of the agent's conduct with the RICS or the CAAV, depending on what they're a member of.
And I think the beauty of the code is there's there isn't anywhere for people can't hide behind the fact that it's not a code that George has written, and it's not a code that the RICS have written in isolation. This is an industry-wide code. So my feeling is there's very few places for a rogue agent to hide moving forwards, and I genuinely think I have very much hope that this we see a change in the sector. It will take time. It will take time because people are stuck in their ways, but I hope this will happen. So.
And Robert, I'm very aware of situations where some of our members have got some really well-meaning landlords who want to do the right thing by the relationship that they've got with their tenants, but for whatever reason, either because it's not something they routinely deal with, the landlord-tenant aspects of property ownership, or because they're too busy doing other things, or whatever, that they just rely upon the agent to give them the advice that they think they need in order to sustain that property interest. And a lot of landlords be out of their depth, in terms of dealing with those relationships, and so they are rather in awe of the agent that they've got, particularly if they come from a well-named firm within the sector. And sometimes they feel themselves impotent to do anything about that, particularly if they're a trustee landlord, for example, and they think they have to be abiding by their financial duties to the trust. I've seen it many, many times where the agent seems to be the one who holds the ring rather than the landlord for whatever reason. But now we have the opportunity for a tenant who has that good relationship with the landlord to say, look, here is a code that we need to abide by. The industry has signed up to this code. Your agent is not complying with this code. This gives you the opportunity to say, look, Mr. Agent or Mrs. Agent or whatever, sort yourself out. And I'm not naive enough to think it's going to change things overnight, but it gives another tool to people that want to have good relationships to be able to fulfill those good relationships. It's not always because the landlord is taking a hard line. It may be because they just don't have the tools themselves to know how to manage their agent.
No, I think that's very sound advice, George, and that leads on to a question for.
I think Matthew wanted to come in there.
Absolutely, Matthew.
I said it at the outset, but I also just want to flag that that's just not. I want to just make it clear that this isn't just a one-sided problem in the industry. There are agents that act on behalf of tenants who play fast and loose as well, and so I think just to give that balance, I think it's almost beholden on you all as members as well to make sure your agent is acting in behalf of the code, because I think that's really important as well, because if we're going to change the sector as a whole, we've all got to come to the table, and I think that's really, really important.
No, absolutely so, and like many nights here that we seem to run out of time before we run out of questions, and which is a very good position to be. But moving on a little bit there with a member from Cornwall, I'm a local authority tenant who is being made to use a joint agent. Now, I've heard of this a few times of late with the landlord when I entered the farm. This led to all sorts of problems and issues. What extent does the code change these things? Can it say, well, we just need one agent or two? How will that be picked up?
Well, I'll let Charles answer the technical point, but it is. Let's just say this was an area of actually quite substantial discussion amongst the working group as we teased through this point. And actually, there was I don't think I'm betraying any confidences, but there was actually some representation from effectively local authority surveyors who, on the grounds of cost, were keen to have as few agents as possible involved in a reletting. So you ended up with one agent dealing with ingoings, outgoings, delapse, and I think we all got to a point where we agreed that was not appropriate, and that people should have the ability to have their own professional advice. And we see it in the private sector. It isn't just public sector landlords. We see it in the private sector quite often, and the code seeks to make that easier for people to say, hang on, we want to be independently represented. And Charles, you might just want sorry to put you on the spot, but
no, it's all right. We did have some prior warning of this question, so I'm primed. Page 11 of the code, it's the last page, is headed "The Role of Professional Advisors and Agents." And the third bullet point on that page tells us that where there are negotiations with an outgoing tenant, the parties, landlord and ingoing tenant, should not share professional representation unless they both provide informed consent. And there are several caveats, one of which is in the exceptional case where they do share professional representation, it is the tenant who calls the shots on who the agent is. As Matthew intimated, that was one of the sections of the code that took quite a bit of work. in the drafting, or not the only one by any means. But I think we got to a good outcome. Historically, where it has happened, it has been the landlord who has imposed a choice on the incoming tenant. This turns that on its head. It is the incoming tenant who chooses in the exceptional case where there is joint representation. And there's a lot of other stuff on page 11 about the potential conflict of interest, which clearly the member from Cornwall who asked this question is very aware of the issue that arises. Page 11, that's the place to look. It answers your question there.
Well, that's absolutely fantastic. Now, I'm very acutely aware that on my timing, and I think I'm not that far away tonight. So I think in closing of the questions that have come in tonight, we just have a comment from a member in Kent, really. Whilst clarity and communication are welcome, aspects of the code for the tenant farmer to define his relationship with the landlord, is it not collaboration that allows for the prospect of an ongoing relationship combining the resources of both parties? Well, I think from what we've talked about tonight, communication and clarity, and if you can get both parties to work together, I think we've kind of got this one cracked, actually. So I think that was quite a good comment to close our question and answers this evening. Any questions that we haven't answered, we'll forward through to our guests this evening, and then we'll put them up on our website, because we always have more questions than we do able to answer. So in closing tonight, I would like to thank our speakers, both Matthew and Charles, and for George for coming in on questions, and also to thank our event sponsors, Rawthorns Solicitors. Our next TFA webinar is due in June. And that was meant to be with Janet Hughes, the coordinator for DEFRA, but we heard this morning that she's unable to speak due to the general election. So we'll keep you updated with our next date. But also, finally, those that are attending the Royal Cornwall Show, George and also our Vice Chair Helen Radnor will be attending the event on Thursday the 6th and Friday the 7th. George, you were based at the Towergate Farm Insurance stand, which is next to the Members Pavilion, and there are still some one-to-one slots available on the Friday with George, but if you contact the office, they will be able to sort that out for you. So on behalf of me, I'd like to thank you all for listening tonight, and we'll look forward to seeing you next time. Thank you and good night.